Hello there, this is a quick video to give you an overview and to explain the buyer representation agreement that I'm asking you to sign. By the time you get through this video, if you have any further questions or need clarification, please feel free to get a hold of me and ask. We're going to dive right in. This is the buyer representation contract. It allows my brokerage to exclusively represent you in the purchase of a property. Please keep in mind that this contract is not saying that you will be buying something. What it's saying is that if you choose to buy something between the dates that we're going to have listed on here, you would be using my brokerage to represent you in that transaction. We're going to put the current date at the top. It's going to say page 1 of 4. Your names will be at the top where it says buyer is, and then the brokerage will be Keller Williams Integrity Realty, and that will give us the exclusive right to assist you in the negotiations and the purchase of a property. Line 7 will be the effective dates that I will be representing you. So we'll have a start date of when I will start representing you and an end date, and that end date will usually occur after the closing of the sale. So typically I like to write the contract out for a 6-month time period to make sure that we are fully covered. Keep in mind that we can terminate this contract at any time as long as we have a written mutual agreement of all parties. My obligation and my broker's obligation to you will make a reasonable effort to locate a property you find acceptable, to use my professional skills and knowledge to assist you in negotiating the purchase of the property, to assist you throughout the transaction, to act in your best interest at all times. Acting in your best interest at all times has to be those subject to the law. I can't break the law, or if we're in a dual agency situation. Dual agency means that I would be representing both the buyer and the seller, and that could get in the way of me acting in either party's best interest at all times. I like to avoid that situation, and if we do come upon that situation, we'll cross that bridge when we get there. I agree that I'll comply with all applicable fair housing and non-discrimination regulations. Your obligation to me is to work exclusively with me on the purchase of a property, to promptly furnish me with accurate and relevant personal financial information to help determine your eligibility to purchase a property. You'll cooperate with me in finding a property to purchase. You understand that once you get into a purchase agreement and it's accepted by a seller, you are legally obligated to purchase that property. If you are in a purchase agreement with the seller and you refuse to close on the purchase for any reason other than the failure of the seller to do something, so if it's a seller's fault, you're not going to be penalized for that, or if there are certain contingencies that will allow you to have an out of the purchase, of course, we'll do the best that we can to utilize those contingencies to get you out if we can. Otherwise, if you flat out just get cold feet and you don't have a legal reason to cancel, there are definitely legal ramifications to that. A seller could seek legal action against you. The broker could also still seek the compensation that they have now lost as a result of you canceling. The compensation that any type of brokerage receives for representing someone in a purchase or a lease or rental, that is going to be determined by each individual broker and the client. What that means is that commissions are not set by the law. They are fully negotiable. Compensation is something that is determined differently from each individual broker that's out there. Speaking of compensation, line 27 says that I do not collect an upfront retainer fee when we start the contract. Number 30 says that I do charge a compensation. I charge a fee, my broker and that blank will say 2.7% of the selling price or $0, whichever is greater. That gets paid at the closing of the sale. We're going to go back to that in a second, but what that says is that you, the buyer, are responsible for paying my brokerage. There are going to be some exceptions to that we'll be talking about in a second. But at this point in time, you will be responsible for paying that 2.7%. Line 34 says that within, and what the blank will say is 180 days, which is 6 months. After 180 days after this contract would expire, and you go back and purchase one of the properties that I took the time to show you, If that is something that you choose to do within 180 days after expiration, I would still get paid the commission that I would have gotten paid if it were still during that contract period. I do have to provide you with a list of all the properties that I showed you, and I'd have to do that within 72 hours after this contract would expire in order for this clause to be utilized. If you do end up in a contract with another brokerage right after the contract with us expires, that would make this section void. Myself and my broker, we are authorized to negotiate and receive compensation paid by the seller or a brokerage that's representing the seller. So any type of compensation that I receive from the seller will reduce your obligation to have to pay me that compensation. So for example, in this contract it says that we charge 2.7%. If we have a seller that agrees to pay me 2.5%, that means that you would be responsible then for 0.2%, the difference. If we have a seller that's willing to pay all 2.7%, that would then reduce your full obligation to have to compensate me the full amount that I charge. So if we get to the point where the seller does agree, we're going to have that written into the purchase agreement, and we are also going to have a second agreement between you and I that says that you understand you are now released from your obligation to have to pay me the commission because the seller is agreeing to do that instead. I cannot receive compensation from any source that exceeds the amount that's agreed in this contract. So if we ended up having a seller that says, hey, please bring me a buyer, I'm willing to pay the buyer's agent 3%, I can't collect all 3%, I can only collect 2.7% because that's the amount that I have in this contract with you. Line 47 pertains to that 180-day clause that we just talked about. It says that you understand you wouldn't have to pay any type of compensation within that 180 days if you end up getting into a representation contract during that time period with another broker. Caution, your actions in locating a property could actually affect my payment of compensation and might put you on the hook to have to pay for all or part of that compensation. So for example, if you go to an open house and you don't tell the agent at the open house that you are being represented by me, and you start working with that agent, asking them questions, having them do things for you instead of me doing things for you, and then you decide you want to offer on that property, that agent might not be willing to pay me a compensation for representing you because they have done a lot of the work up front themselves. So just keep in mind that if you do go to an open house, let them know right away that you're working with me so there's no question about who's representing you and who should be getting paid that buyer broker compensation for doing so. This discloses the general nature of the property that you are going to be purchasing, and typically that will be residential personal property that we'll be checking. Buyer acknowledges that you might be required to pay certain closing costs, which could increase how much money you have to bring to the closing. Advice here, if you are at the closing and you're taking a look at the documents that need to be signed, and you need some legal advice about them, we cannot give you legal advice about those closing documents. Neither can the closing agent that's sitting with you to help you sign the documents. If you need legal advice, then you would have to seek that out with an attorney. Once we have a purchase agreement signed, we do need to get you connected to a title company. And that title company will then help put together all of the paperwork that you need to sign at the closing, will help to make sure that you've got a clear title, to make sure that all the proper documentation is there and ready to roll in order to be able to give you that full title and full ownership. By law, you have the choice to either say you're okay with me introducing you to a title company and helping to make those closing arrangements, Or you've got the choice to say, you know what, I want to go out and seek out my own title person, hire the title company on my own, or hire an attorney to do the closing for me. So you get to select whether or not you want to do line 71 or 72, and then you will initial at line 73, indicating your choice. We do have something out in the world of real estate called FIRPTA. This is a situation where we have a seller who is a foreign investor that is selling the property. This doesn't happen too often, and if it does occur, they let us know before you even look at the property that this would be the case. What this means is that if that foreign investor is selling the property, they are going to have to pay income tax on the money that they're making from the sale. However, if they are a foreign investor, they are not able to directly pay the U.S. government that income tax, so they would need some assistance from the buyer to do so by giving the money to the buyer, assuming the buyer will be a U.S. resident, and arrangements will be made for the buyer to pay the tax on behalf of that foreign investor. I won't dig much deeper into that because it, like I said, doesn't happen too often, but we just want to introduce you to that concept. Our broker is recommending that you have you have a private home inspection done as a part of the sale and make that a contingency, and to also make you aware that there are home warranty programs available to purchase after the closing if you choose to do so. This box talks about agency representation. This section talks about the concept of dual agency. Dual agency is when we have one agent that's representing both the buyer and the seller, or if it's the same brokerage that's representing both the buyer and the seller. The agent representing both parties is definitely a potential conflict of interest. When we have the same brokerage representing both parties, it is less of a conflict of interest because you have two separate agents, and oftentimes there's no financial benefit to that like there would be if it's one agent representing both parties. You have to make a choice and indicate whether or not, as we go out to look at properties, if you are interested in looking at properties that are listed by my brokerage or that are listed by me. So you will have to choose either line 99 or line 100, and then you will sign indicating what your choice will be. You understand that I'll be working with other potential buyers at the same time I'm working with you. I might be showing them the same or similar properties as I'm showing you. You also understand that the properties that we look at could be listed by sellers that I have worked for in the past. I might have information about their finances or personal information. If that is the case, I cannot disclose that to you or anyone, even though I don't represent them any longer. Termination of fiduciary duties means that once I am finished representing someone and the contract is canceled or it's expired or we close on the sale, confidentiality will always be in place, meaning I will always have to keep your personal information confidential for the next 100 years. Predatory offender information, just another reminder that it is your responsibility as the buyer to investigate if there are any level 3 sex offenders living in neighborhoods that you're interested in living in. You are provided here with a website and a phone number to obtain that information. This contract and any addendum or amendments that are signed by all parties are binding. Any changes or additions need to be made in writing as well and attached to this agreement. Emails, text messages, phone calls, and so forth do not count. Electronic signatures are legal and the same as handwritten signatures. You are giving me your consent to communicate with you by phone, email, fax, email, text message, and so forth. So you will be signing and dating here, and I will do the same. That will make this contract official. And then the last page of this talks about wire fraud alert. Please be careful. We have had circumstances in my office and in other offices in the past where we have people that are hackers and they are claiming to be a part of the transaction, claiming to be a title company, asking for bank account information. Please do not give that to anyone before checking with me first. And as I said before, if you have any questions or need clarity, please ask before you sign. Thank you.